Identify all partners you have had during the marriage by name and city, state, or county.
There was a lot of unknowns happening during the marriage, a lot of more affairs than what has even been disclosed, and a lot of what, frankly, we believe is very reckless behavior. That
Attorney Amber Solar here for the plaintiff, and Attorney Robert Zeta on behalf of the defendant. We are here on the plaintiff's motion to compel discovery, and I have read the motion. Ms. Solar, do you have anything else you'd like to say about it?
I do, Your Honor, and I'll be brief. First, there was some additional, after the motion was filed, there was some additional production of some statements as well as a supplement to the request to produce. So largely the remaining issues are going to be with the interrogatories themselves and the request for the defendant medical records related to the Kent County Health Department. Speaking first to the interrogatories, there was a request number 3 of the interrogatories regarding identifying sexual partners. That was objected to by the defendant, claiming privilege. We do not believe that there's any privilege from that. There is a false claim that has been made by the plaintiff. That was just very recently, the defendant took a position that my client was living a similar lifestyle to the defendant, which is frankly untrue. But in order to be able to properly defend against those reciprocatory claims, we do need the answers to these interrogatories, and we do need the health information that was requested as well. Since we are live and on the record, I'd prefer to not speak openly about what specific records are being requested, but it was laid out in the motion. And
I did read it, so there's no need to do that.
Thank you. We're happy to enter into a protective order for those records. We have no objections to that, but we do believe the records are needed as to speak to fault in the upcoming trial that is scheduled for just a few weeks away at this point. We would request, Your Honor, that a couple of things. First, while the documents as far as statements were produced, we would ask that the court order an ongoing obligation to the defendant to continue to supplement those responses should any additional statements be found to be missing or any account information was not provided. We would also request that interrogatory number 3 regarding partners be answered in full. Finally, we would request that as to the health records, that either the court order the defendant to sign a waiver that has been provided to him for the Kent County Health records, or in the alternative, that the court order the Kent County Health Department to provide those records to plaintiff. Finally, Your Honor, throughout this case, defendant has failed to timely produce the records and made these new claims sort of at the last minute, which has really put the plaintiff at a severe disadvantage while prepping for the upcoming trial. Ms. Large did attempt to reach out to defendant's counsel prior to filing this motion to compel. I'm going to attempt to remedy the failures to properly answer, but was not given a response. Plaintiff supplements were only made by defendant over the last few days, and only in part. And that was made because of, sort of last minute. Again, it's having an effect on plaintiff's ability to be able to properly prepare himself for the upcoming trial. Because of this, plaintiff is asking for attorney fees and costs as they relate to this motion as well.
Mr. Zeta?
Thank you, Your Honor. First of all, I am covering this hearing for my partner, Michael Zeta, who's the attorney of record for Mr. McFarlane. With regard to this motion, it's my understanding then that the three issues are remaining. That's requests 3, 4, and 5 as contained in the motion. The other matters have been resolved, according to my understanding, because of work that has happened since the motion's been filed.
All right,
So,
I'm going to stop you a moment just to confirm with Ms. Solar. Is that an accurate statement?
That is, Your Honor.
Okay.
As I stated, those have been complied with at this point.
That's what I thought, but I just wanted to remove any doubt from the record. All right, Mr. Zeta.
thank you, Your Honor. The first item to be addressed then is request 3, which is to identify all sexual partners you have had during the marriage by name and city, state, or county. We have asserted privilege as one basis to deny that. Secondly, it was asserted that discovery wasn't reasonably calculated to lead to admissible evidence, but really was designed to harass the defendant more than produce necessary discovery. It's the argument of defendants that any person involved in an encounter like this would have a reasonable expectation of privacy, and knowing their name or a person's name, again, doesn't seem to be required. It was admitted that these encounters took place, as my understanding in terms of discovery, and really this could have been asked differently if the object is to determine how many encounters, then that could have been asked, but that wasn't the question. It's to identify persons rather than numbers. So that's our argument on that request. On request 4 and request 5, again, privilege was asserted, and the privilege that was asserted was doctor-patient or physician-patient privilege, which is MCL 621-57. This isn't just something that can be invoked by a doctor. It's something that can be invoked by the defendant, as he has done in this case. He has a privilege with regard to medical information, and we would ask that the court protect that privilege by virtue of its ruling. Again, at this point, the items that are sought are health records. There's nothing else in 4 and 5 other than health items. As to attorney fees and costs, Your Honor, defendant has been, first of all, asserted his responses to those requests in good faith, where he believed that privilege was in fact involved. And subsequently, once this motion was filed, again, has been working in good faith to trim the issues down to where they are this morning. So we would ask that the court deny the request for attorney fees and costs and deny the requests 3, 4, and 5 that are advanced in the motion. Thank you.
Thank you. Ms. Solar, I guess the question the court has at this point is, why do you need the names if there's an admission that there have been multiple affairs?
Well, Your Honor, I think more so than the names, if the court is unwilling to allow the names, we would need at a minimum the number, and we would like some location information as well. It goes to the veracity of plaintiff's claims that there was a lot of unknowns happening during the marriage, more affairs than what has even been disclosed at this point, and a lot of what, frankly, we believe is very reckless behavior that has put my client at risk and contributes to the question of fault in this matter.
All right. Any other rebuttal you'd like to make?
No, Your Honor, I will rely further argument on what was placed in the motion itself.
All right. The court finds that the interrogatories requested are reasonable, material, relevant, but I will And so the court will grant the motion, subject to a protective order as far as the health information is concerned, or that the defendant sign a waiver for those particular health records so that they can be released to the attorney in this matter. That question 3 be limited to numbers and locations rather than specific names. Although the court would be willing to revisit that if something changes in terms of why that might be relevant, but at this point I don't see that it's relevant on the actual names since there's been an admission. As far as attorney fees go, the court will reserve attorney fees so long as there are no further discovery motions that are where the plaintiff prevails in this matter. And remind actually both parties that they have a duty to supplement a discovery pending trial or settlement. Is there anything else that the court needs to address today?
I don't believe so, Your Honor.
Your Honor, just to specify in the order itself as to production, did you want, should I put in the order that defendant will sign the release, or did you want me to put language in that where the court is ordering the health department to
Sign the release. Health officials have less of a problem when it's the patient who is releasing as opposed to the court ordering it.
And then I will draft the order, Your Honor. Thank you.
All right, thank you. We're adjourned.